the members of the family of Justice Sajjar, Mr. Ganguly, Professor Rao, Sanjay Parekh, and all the dignitaries who are present here today. I must confess that it is actually an honor for me to be able to deliver this lecture in the memory of Justice Sajjar. I have known him virtually from the first day when I joined the bar in 1977. I have appeared in his court on several occasions. I've actually attended his court even when I did not have a case, just to see how polite he was and how he managed the court, how he dealt with cases, how he dealt with juniors and seniors. So it was really a very pleasant feeling that I had every time I attended his court. After his retirement also, I met him occasionally, perhaps more often in the swimming pool in the Gymkhana Club, where we used to exchange pleasantries occasionally. So really it's a privilege for me to be here today, and I would like to thank you for giving me this opportunity. Now, my lecture is really on human rights, the concerns and challenges. Human rights jurisprudence is an extremely vast topic of discussion, and it is not advisable to limit it to human rights as defined in the Protection of Human Rights Act of 1993. The reason is that this act limits human rights to mean the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. For the purposes of the Act, international covenants mean International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, and such other covenant or convention adopted by the United Nations as the central government may by notification specify. As one would expect, it is difficult to get hold of the notifications, if any, issued by the central government, which accept and acknowledge international conventions ratified by India and which also recognize other human rights. I have in mind, for the present, the Convention on the Rights of the Child, or CRC, and the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. Given the vastness of the subject on human rights, I propose to limit this memorial lecture to some facets of the rights of children and women, particularly in the background of the dignity jurisprudence developed by our Supreme Court. I may also be permitted to say a few words on a grave violation of human rights through what are commonly referred to as encounter deaths or extrajudicial killings, particularly in the context of a recent incident in Telangana. The human rights of children are perhaps the most neglected of all human rights. Unfortunately, this neglect impacts almost 40% of our population and also future generations. The failure to implement the rights of children as recognized by the Juvenile Justice, Care and Protection of Children Act 2015 and the Convention on the Rights of the Child is a matter of grave concern. Day in and day out, there are reports of the exploitation of children in varied activities, including child labor in hazardous occupations such as mica mining, non-payment or delayed payment of wages that are much lower than prescribed, and of course other forms of exploitation. It has been reported that 1 out of every 10 workers in India is a child, and that children between the ages of 14 and 17 years engaged in hazardous work comprise of more than 60% of India's child labor workforce. The National Policy for Children of 2013 provides that children in difficult circumstances are tracked, rescued, rehabilitated, and have access to their right to education. While the objectives of the national policy are more than welcome, what is important is the level of achievement and success in the implementation of the objectives. There is nothing in the public domain on this. Similarly, the National Plan of Action for Children 2016 also has some excellent objectives and draws upon the Sustainable Development Goals to provide a broad framework But again, the question is of implementation. It is true that the state has introduced some measures like Operation Muskan and Operation Smile that have achieved occasional success, but follow-up action is also necessary with regard to the rehabilitation and reintegration of rescued children into society. Human rights can be used not only as a shield, but also wielded as a sword. Amongst the worst violations of the human rights of the child is the custom of child marriage. Child marriages take place across the country in spite of the Prohibition of Child Marriage Act 2006 and its predecessor, the Child Marriage Restraint Act of 1929, that specifically makes a child marriage as a punishable offense. In fact, there is a particular day in a year, Akshaya Tritiya, when it is considered auspicious to solemnize a child marriage. Of course, all governments are making an effort to take action against child marriages, but it is quite strange that over the last more than 10 years, very little has been achieved by way of a substantial reduction in the number of child marriages, which take place not sporadically, but in hundreds. Target 5.3 of the Sustainable Development Goals requires India to eliminate child, early, and forced marriages by 2030. But the Government of India did not provide any update on achieving the target during its voluntary national review at the 2017 High-Level Political Forum. A report prepared by the National Commission for the Protection of Child Rights in collaboration with Young Lives was released in 2017 and is titled A Statistical Analysis of Child Marriage in India based on Census 2011. This report states inter alia as follows, and I quote, "Child marriage is not only a violation of human rights, but is also recognized as an obstacle to the development of young people. The practice of child marriage cuts short a critical stage of self-discovery and exploring one's identity. Child marriage is an imposition of a marriage partner on children or adolescents who are in no way ready and matured and thus are at a loss to understand the significance of marriage. Their development gets compromised due to being deprived of freedom, opportunity for personal development, and other rights including health and well-being, education and participation in civic life, and nullifies their basic rights as envisaged in the United Nations Convention on the Rights of the Child ratified by India in 1989. Marriage at a young age prevents both girls and boys from exercising agency in making important life decisions and securing basic freedoms, including pursuing opportunities for education, earning a sustainable livelihood, and accessing sexual health and rights. There is more than enough documentary evidence and also physical evidence in the form of women who were married while they were children to condemn the practice of child marriages, but it continues to flourish in many parts of India due to an absence of effective implementation of the law and recognition of the human rights of children. In fact, it has been found that in the first decade of this century, about 20% of the married females had been married as children. Trafficking of young girls and even young boys is a matter of grave concern all over the country. Human trafficking is abominable per se, and it is worse when children are trafficked in large numbers. The 2019 report of the US Department of State has mentioned in its Trafficking in Persons report, and I quote, "Traffickers have coerced poor parents to give up their children and forced the children to work and in one case steal in large cities. Multiple organizations note physical violence against trafficking victims in both forced labor and sex trafficking is particularly prevalent in India. Unregulated work placement agencies reportedly use false promises of employment to lure adults and children into sex trafficking or forced labor. Some traffickers force women and girls to conceive and deliver babies for sale. Experts estimate millions of people are sex trafficking victims within India. Traffickers exploit women and children in sex trafficking in religious pilgrimage centers and in tourist destinations. Traffickers subject women and girls, predominantly from Nepal and Bangladesh, and to a lesser extent from Europe, Africa, and Asia, to sex trafficking in India. Traffickers exploit Indian and Nepali women and girls in India as orchestra dancers, where girls work for dance groups hired to perform at public functions but are subsequently subjected to sex trafficking. Traffickers use online technology to facilitate sex trafficking and fraudulent recruitment. Some traffickers kidnap children from public places, entice girls with drugs, and force girls as young as 5 years old in sex trafficking to take hormone injections to appear older. Unquote. What could be more abhorrent than the trafficking of women and children for sexual favors? Are these human rights issues being addressed and remedial measures, if any, implemented? I have been given to understand that a detailed report on trafficking has been prepared for the government, but for some reason it is not being released. If this is true, it should be appreciated by policy and decision makers that unless important facts and figures are thrown open for discussion, we will not be able to solve grave human rights violations of our own people. An ostrich-like response will not lead us anywhere at all, except perhaps in a downward spiral. To compound matters, several cases of child sexual abuse, which are not being recorded or followed up, perhaps due to apathy or due to the need to keep the crime graph low, so that the state can claim success in bringing down the crime rate or at least keeping it under control. The tragedy of the public discourse about children is that while undue attention is paid to crimes committed by juveniles, very little attention is paid to crimes committed against children. Human rights are not a one-way street where only the accused have rights. Even victims of crimes such as children have rights, which need to be enforced, and greater importance given to victim rights. Monetary compensation to the family of a child is not enough. Much more needs to be attended to, such as counseling, psychosocial rehabilitation, and indeed reintegration into society. Visits to observation homes for children and other childcare institutions reveal a dismal state of affairs. These institutions are guided by the provisions of the Juvenile Justice Act and the rules framed thereunder, read with the requirements of the Convention on the Rights of the Child. However, very little has been done to improve the living conditions of children in many of these institutions. There are regular reports available in newspapers of unsavory activities going on in some of these homes, including complaints of sodomy. These might be extreme examples, but there are issues of hygiene and sanitary conditions in many homes, lack of adequate nutrition for children, absence of any worthwhile activity to keep the children occupied or to develop some skill or talent. Many NGOs across the country are doing their bit for the protection of the human rights of children, but that cannot be the only solution. They need active support from the state, which in most cases is unfortunately not forthcoming. On the human rights of women, a debate is brewing on the bodily rights and integrity of a woman and her choices, particularly with regard to her choice of aborting a fetus. A study reported by The Lancet concluded that in the year 2015, there were as many as 48 million pregnancies, and almost one-third of them, that is about 15 million women, underwent an abortion for a variety of reasons. Does a woman have an absolute human right to abort a fetus, even in a non-life-threatening pregnancy? This question can get further complicated if we consider unwanted pregnancies through rape, not only of adult women, but also of minor girls. What is the choice before a woman whose bodily integrity has already been violated? A study conducted by Pratigya has indicated that between 2016 and 2019, As many as 194 women had gone to different courts for the termination of their pregnancy, and of these, 21 cases had been filed in the Supreme Court. A fairly large number of these cases related to pregnancies caused by the rape of young girls. What are the options before them? They are too young to make an informed choice and would have to face a variety of issues such as social stigma and the impact on mental health, lack of financial support to bring up a child, perhaps as a single mother, and so on. Unfortunately, we have not been able to develop any jurisprudence on this pressing human rights issue or arrive at a balance to tackle these situations, or a balance between those championing the cause of free choices for women and pro-life activists. The increasing incidence of sexual harassment of women, including rape, is another matter of grave concern. The report of the National Crime Records Bureau for 2017, that was released only in 2019, indicates that on an average, a rape is committed every 15 minutes, and 1/3 of the victims are minors. Very few cases make it to the headlines. In addition to this, on an average, one woman is burnt to death every hour for dowry, and 241 cases of sexual harassment are registered every day. It is not possible to guess how many rapes or dowry deaths or cases of sexual harassment or domestic violence are committed on a daily basis but not reported to the police. The human rights of women and girls appear to be only talking points and not actionable points. I say this because there are more than enough funds available for women's safety, but these are not being utilized. In response to a question raised in Parliament, the Honorable Minister of Women and Child Development gave details on 29th November 2019 on the utilization of the Nirbhay Fund, which was established in 2013 for implementation of initiatives aimed at enhancing the safety and security of women in the country. She informed that the funds released for Nirbhaya funded projects by the Ministry of Home Affairs have been utilized only to the extent of 9% over the last 5 years. In Maharashtra, it is 0%. Similarly, funds released by the Ministry of Women and Child Development have been utilized only to the extent of 20%. And in Madhya Pradesh, it is 0%. In all 11 states to which the Department of Justice has released funds, the utilization is 0%. It is this lack of concern for the safety and security of women and children that leads to grave violation of the human rights, which dangerously impacts society. As I have already mentioned, though there are several other human rights of women that are violated on a daily basis, but I'm not referring to them for the moment since the discussion would require at least a few days. On encounter deaths and extrajudicial killings, the recent encounter between 10 policemen and 4 accused persons, which resulted in the death of the accused, who were alleged to have planned and committed the brutal rape and equally brutal murder of a doctor in Telangana, has led to a huge debate. Many have celebrated the encounter deaths and many have condemned it. The full facts and details of the event are not yet available since the incident is pending inquiry. Therefore, it may not be advisable to be judgmental about it just now, notwithstanding the reportage of some suspicious circumstances. But it is necessary to be aware of the guidelines issued by the National Human Rights Commission on the subject of police encounters. The first set of instructions given by the NHRC was through a communication issued by Justice M.N. Venkachalaya on 29th March 1997. The communication was addressed to all chief ministers regarding the procedure to be followed in cases of deaths in police encounters. The communication begins by stating, and I quote, "The Commission has been receiving complaints from the members of the general public and from non-governmental organizations that instances of fake encounters by the police are on the increase and that police kill persons instead of subjecting them to due process of law if offenses are alleged against them. No investigation whatsoever is made as to who caused these unnatural deaths and as to whether the deceased had committed any offenses. Unquote. The communication virtually presages the police version in Telangana as reported in the media. It was said in that communication, and I quote, "The practice obtaining in Andhra Pradesh, as perhaps elsewhere also, is that when an encounter death takes place, the leader of the police party engaged in the encounter furnishes information to the police station about the encounter and the persons that died. The stand taken by the police in all these cases, brought by the Andhra Pradesh Civil Liberties Committee, was that the deceased persons, on sighting the police, opened fire at them with a view to killing them and were therefore guilty of the offence of attempt to murder under section 307 of the IPC. The police justified their firing and killing as done in exercise of the right of self-defence. This information was recorded in the police station describing the persons killed by the bullets fired by the police as accused, and FIRs were drawn up accordingly. Without any more investigation, the cases were closed as having abated in view of the death of the accused. No attempt whatsoever was made to ascertain if the police officers who fired the bullets that resulted in the killings were justified in law in doing so, and if otherwise, whether and if so, what offences were committed by them." Unquote. The communication then briefly described and reiterated the correct procedure to be followed as laid down on 5th November 1996 in the event of deaths in police encounters. That's about 25 years back. These instructions were revised by the NHRC on 2nd December 2003 and then again on 12th May 2010 through a letter sent by Justice G.P. Mathur communicating the final guidelines. The letter clearly stated that the police does not have a right to take away the life of a person. Under the scheme of criminal law prevailing in India, it would not be an offence if the death is caused in exercise of the right of private defence. Another provision under which the police officer can justify causing death is Section 46 of the Criminal Procedure Code. This provision authorizes the police to use reasonable force, even extending up to causing death, if found necessary to arrest the person accused of an offence punishable with death or imprisonment for life. It is evident that death caused in an encounter, if not justified, would amount to an offence of culpable homicide. The letter noticed that most of the states, this is in 2010, the letter noticed that most of the states are not following the recommendations given by the NHRC in true letter and spirit. Justice G.P. Mathur then provided the revised procedure to be followed in all cases of deaths in the course of police action. The revised guidelines of the NHRC provide, inter alia, that when information is received about death in an encounter, that information shall be entered in an appropriate register. Where the police officers belong to the same police station as members of the encounter party, it is desirable that such cases are made over for investigation to some other independent investigating agency. A magisterial inquiry must be held in all cases of death which occurs in the course of police action, preferably within 3 months, and prompt prosecution and disciplinary action must be initiated if the members of the police party are found guilty in the magisterial inquiry or police investigation. It appears that subsequently guidelines were issued for conducting a magisterial inquiry, and it was provided that the magisterial inquiry should now be conducted not within 3 months, but without undue delay. and should cover a variety of aspects which include examination and verification of the records. Hopefully, the NHRC will ensure that its guidelines are followed with regard to the police encounter in Telangana, notwithstanding the public sentiment and accolades showered on the police party. It would also be advisable if the report is placed in the public domain so that everyone is aware of the guidelines and the recommendations and whether they have been followed in true letter and spirit. Sharing information is necessary since, according to the police in Uttar Pradesh, 103 criminals have been killed in encounters over the last 2 years. But the investigation or magisterial inquiry reports in these cases are either not available or not easily available in the public domain for ascertaining whether the guidelines and recommendations of the National Human Rights Commission have been followed or not. There is nothing secret about these incidents. It must also be remembered that the Supreme Court has held that the right to know is a human right. In conclusion, I would like to conclude by very briefly referring to the right to food, for which PUCL, which has been adverted to by Mr. Parekh as well as by Mr. Ganguly, launched a campaign and played a very seminal and active role. Justice Sachar was associated with this organization as its president from 1986 to 1995. The campaign for the right to food eventually led to several orders passed by the Supreme Court, which recognized the right to food as a human right, and eventually enactment of the National Food Security Act 2013. Justice Sachar's contribution to the understanding and development of human rights is of considerable importance and goes back several decades. And I think all of us must acknowledge it and salute his contribution through an annual memorial lecture. Thank you.